partner in the matter of Discovery Land Company LLC and others, Axis Specialty Europe SE.
Yes, Mr. Fleming.
Thank you, my Lord. My Lord, I've agreed with my learned friend, Mr. Lawrence, that I will conclude my oral submissions by 12:30 at the latest today. You'll then have half an hour before 1 o'clock, so the appeal will conclude, the hearing will conclude at 1 o'clock.
Yes, thank you.
And I hope, my Lord and my Ladies, you may have received by your clerks copies of the transcripts of yesterday and
yes,
the first.
I've certainly not seen them yet, but that doesn't mean to say that my clerk hasn't got them. Yeah, she's signalling that she's got them.
Yes.
She's obviously going to put them in a folder for me.
She's the only clerk whose email address we actually have, so they've certainly gone to her. And she said she would circulate them. So, my Lord, overnight, and my Ladies, I said I would check 2 points, which we've done. Firstly, as to motive, the question was whether it was put to Mr. Prentice in cross-examination that he didn't ask about misuse of client money because he didn't wish to ask awkward questions. The answer is no, that was not put to him in cross-examination. We also I also said that we would check whether Axis had submitted in this court that there was evidence which Axis had asked the judge to consider, but which he'd failed to consider. The short answer is in oral submissions, no, but in written skeleton argument, yes. I should, if I may, just expand on that. In paragraph 37 of Axis's skeleton argument, page 42 of the core bundle, Axis criticised, actually the criticism was at the top of page 43 of the core bundle, the judge for having overlooked, they said, the emails of 21st August 17 and 20th December 17, referred to at paragraphs 35E and J above. Now, as to 35J, that's on page 41 of the core bundle, an email of 20th December 2017. As far as we can see, that point wasn't made at all by my learned friend in his oral submissions to this court. He did, however, refer to the preceding email, the one at 35E on page 40 of the core bundle. That's an email dated 21st August 2017, which appears at tab 28 of volume, what I imagine is volume 1 of the supplemental bundle. That's about barleycorn funds.
Well, maybe I'll say, my own friend of the court, some time in relation to this. When I come to reply, I am not going to attempt to submit that this court should be allowing this appeal because the learned judge completely failed to have regard to some critical piece of documentary evidence or another piece of critical evidence, whether because of lapse of time or for some other reason.
So you don't pursue ground 2 of your...
Not, I know it's there, my lord, but I'm not going to ask the court to attach any significant weight to that when I seek to persuade the court in reply that this appeal is a good appeal.
And the context in which I was making it, the point yesterday, was it's the sort of point which you would expect to see if somebody was going to run a delay argument, a delay of judgment argument.
My lord, I fully accept that. If the delay argument, of course, is what it is, and I can mention that in reply if need be, depending on what my learned says. But as I say, I hope it assists and saves time for me to make clear that when I come to reply, I am not going to be submitting to this court that there was some critical piece of evidence.
What about ground 3? Are you pursuing that he accorded insufficient weight to evidence from other employees about the perceptions of Mr. Jones?
Yes, that is pursued. It's not central, but it is pursued. That relates to the 2010, principally to the 2010-2012 evidence that the court has seen, and of course I understand the point that is made about the SRA looking at that and taking no further action. But that is not abandoned. I'll I'll sit down if I may, because I'm taking up my
Yes, no, thank you very much. Thank you for that clarification.
Well, I'm grateful for that. I was simply going to say that in oral submissions, my own friend had referred to this other email as a relatively anodyne starting point. So I didn't understand.
Well, grant two's not been pursued.
Precisely. So, my lord, in terms of what of structure, what I plan to say today, I'd like to finish off my submissions on points taken in relation to the facts, then move on to the two grounds in the respondent's notice that I haven't yet addressed. Firstly, whether, as a matter of the construction of this policy, the judge was right or wrong, as we contend. And this is an alternative submission. My primary submission is the appeal should be dismissed as to condemnation, should be dismissed because it fails in terms of overturning the judge's findings of fact. And if you're with me on that, then I don't need to address my other arguments. But you may, of course, not be with me on that, so therefore I wish to address those two arguments. The first is that the judge was wrong to hold on the wording of this particular policy, that condoning a pattern of behaviour out of which the relevant dishonest acts arise is sufficient to fall within clause 2.8. And then the second is, if that were rejected, then I will submit that even if some findings of fact are overturned, it would not be sufficient to bring this case within the type of case which the decided decisions of Goldsmith, Williams and Zurich and Karim are. When we look at the facts of those cases, they're very different from the facts of this case, and even if some findings were overturned, there wouldn't be a pattern remotely resembling the pattern found in Karim and Goldsmith, Smith, Williams. And then finally, I wish to make some short submissions on aggregation. Well, Lord, there's one matter I'd just like to raise on the timetable. I raised this yesterday morning with my friend before the hearing started. Because we raised these two arguments I just mentioned in our respondent's notice, we don't have a skeleton argument from Axis about them for the purposes of this appeal, because they don't have to serve any skeleton argument in response to respondent's notice. Now, as far as the motive point, which we also mentioned in our respondent's notice is concerned, Mr. Lawrence did address that in his submissions, and so I know what he says about that, and I tried to address it yesterday. But so far as these points are concerned, I don't know what his arguments are going to be for this appeal. I know what his conclusion is, which the judge was right about in the findings he made, but I don't know what his arguments are.
So what you're saying is, if he says something in his reply or response to your respondent's notice, you may want to say something else.
Exactly.
Yes. Well, Mr. Lawrence has half an hour to deal with everything. He won't be able to say that much. So hopefully you can, anything you do need to say can be dealt with quite promptly at the end.
I imagine so, my lord. I don't know, but I imagine that will probably be the case. Yeah.
And if you're able to finish a bit before 12:30, it may be that there will be some time.
Yes.
Anyway,
I'll try and do that. I can see that would be very helpful.
It would.
Yes. Right. So, my lord, may I then come back to the facts? And the next issue of fact that was raised by Axis is the further SRA investigation in 2017. Now, it's fair to say that in his oral submissions, day 1 of the transcript, page 150, lines 7 to 9, Mr. Lawrence said that the evidence about this investigation was, quote, not central to the attack on Mr. Prince's position, which I'm developing. So it seems it's peripheral, but he did make the point that if you look at tab 1, bundle 1 of the supplemental bundle, tab 25, page 121, and in particular if you go to, yes, page 121, if you...
I'm terribly sorry, can you give the reference?
Yes, sorry, my lord. Supplemental bundle, I imagine it's bundle 1. I've only got one bundle.
Which tab?
Tab 25.
Yeah.
Page 121.
Yes.
Now, towards slightly below halfway down this page, we can see a reference, Credit Reno Property Holdings, £400,000 debit, balance 400,000. And then underneath that there's another figure of 400,000, but the payee or description is redacted. And then there's a figure of balance 0.37, account total 0.37. So the point taken by Mr. Lawrence is that that was a document which, if you read that line, tended to suggest that there was no money held on client account for Reno. And what he said in the transcript, day 1, page 150, lines 4 to 6, was that this was, quote, consistent with the case being advanced about Mr. Prentice's knowledge at some level of the fact that the Reno money had gone. But he didn't, as I read the transcript, say at what level. Now, my lord, the judge found at paragraph 81 of the judgment, page 138 of the bundle, that line 4 of that paragraph he said, I am even with skepticism, I'm unable, first of all, he rehearsed Axis's submission on this, even with skepticism, I am unable to conclude that Mr. Prentice was lying to the court when he said he had not looked at the material. The likelihood is that here too he just left things. Now, my lord and my ladies, in our submission, firstly, no Henderson and Foxworth error has been shown in relation to that, but secondly, there was abundant material to support that finding. As the judge said at paragraph 78 on the preceding page, and this is a reference to an email of sorry, I think I may have got the wrong paragraphs here. Yes, I'm sorry, I'm not sure he necessarily referred to this email, but I do want to refer to it anyway. In the supplemental bundle 1 at tab 24, page 118, you can see that on the 11th of July, this is the day after the date of the SRA's letters notifying Mr. Jones and Mr. Prentice of the investigation, Mr. Jones sent an email to various people, including Mr. Prentice, headed all, so presumably people who he wished to involve in the inquiry, at Jirehouse. This came in from the SRA this morning. It's a spot visit focusing on business management, particularly client and office accounts and the health of the business. Whilst it may be routine from something, more likely to be in trigger because we've had 3 or more complaints. Next paragraph, most of the items fall within somebody's purview, redacted, so not Mr. Prentice. But of the others, V, that must be Mr. Prentice, will deal with an insurance summary. Then he sets out various other people. So what Mr. Prentice was asked to do was to deal with an insurance summary. And an insurance summary doesn't involve poring over client accounts. If we go back to tab 22 in the same bundle, page 113, this appears to be also on the 11th of July, there's an email from Mr. Prentice copy to Mr. Jones and copy to somebody else saying, can you pop up to Stephen's room, please? So presumably, since Stephen, this was a third party who was being asked to come to the room, and the redacted person replies at the top of the page, working from home day, I've read the letter and we are totally up to date with accounting up to 30th June. I'll arrange the bank confirmation. So that would appear to be somebody whose job it was to deal with accounting. And they were dealing with accounting, and they were reassuring, inter alia Mr. Prentice, that the firm was up to date with accounting matters.
Well, I don't know that that's to do with the SRA visit anyway, particularly, because although it says subject SRA investigation, if you look at the chain of emails that start at 114, Mr. Prentice has raised something with Mr. Jones, which is an attachment which we haven't seen. Mr. Jones says, I can only think it relates to such and such dispute which is being settled. Let's talk to X urgently. And then that's followed through, and they do try to talk to X about whatever that is, and he comes back. So it's all to do with this mysterious letter which we haven't seen.
That's certainly true, but the subject is re-SRA investigation at the bottom of 113.
But it doesn't look as if it's got anything to do with Reno anyway.
It's not specific to Reno, no. None of this investigation is specific to Reno. Certainly not. But in our submission, it's probably specific to the SR investigation, the notice of which, as we've just seen, was the letter which we've got in the bundle I can show you is dated 10th July, and the email we saw a moment ago, 11th July, suggested it had arrived by post on the 11th. The notices are at tab 20, page 107. That's Mr. Jones's notice. And tab 19, page 103 is Mr. Prentice's notice. And if we look at 109, we can see in the appendix a list of documents, almost all of them, very largely in accounts nature, which were going to be needed to be made available for the last 3 months. Then if we go to tab 23, please, page 115. This is the 12th July from Mr. Jones, bottom of the page, to somebody whose name is redacted, so not Mr. Prentice, but he's copied in. Subject SRA audit. Would it be possible to change your days next week so you are here throughout the SRA audit? I think it's important you are always on hand. To which that unidentified person replied at the top of the page, already sorted, totally agree. So again, it appears somebody else. It's important that somebody else should be there to deal with all these accounting issues, not Mr. Prentice, who'd been asked to do the insurance summary.
Again, these are matters which were fully considered by the judge.
Yes.
And he reached conclusions
Yes.
which on the face of them seem to be open to him.
Absolutely right.
And which Mr. Lawrence has not exactly gone to town on. Yeah, I think he said it was not central.
He did say it was not central, but he did say that in some sense Mr. Prentice might have read that document. And I take the point, I should deal with this fairly briefly in the circumstances, but there is one more point I'd like to make on this, if I may.
Well, the judge found as a fact that he said he didn't look at the material.
Yes.
And even if he had, he wouldn't have made any more of it than the chap from the SRA did.
Yes. So as long as that's not challenged, then I needn't say any more, or at least maybe one sentence at most.
Well, maybe it's... going further than I should, but at the moment I can't see any basis upon which one could say that the judge was wrong about that. He saw the material, heard the witness. We haven't seen what the witness said about this.
No. And the other point is,
there's not been a direct challenge, as I see it, to the judge's finding on that regard. I just don't see where we go on it.
yes. Well, I respectfully agree. So I was going to point out that the volume of accounts documents were about 80 pages of extremely dense material. That's clear, agreed on the correspondence, but I needn't do that if, in light of what your lordship has said.
Well, there's an extent to which you're defending a windmill which isn't even being tilted at.
Well, I don't want to waste the court's time, certainly. So I, in light of that indication, I won't go on to the other point in relation to those documents.
I mean, you've just gone through that much more thoroughly than Mr. Lawrence did. I understand why. But,
Yes. Well, I don't want to be excessively thorough, but
yes,
nor do I
no,
wish to
I'm
lose the appeal
not
to
being
Lawrence,
critical at all. I'm just
Yes.
trying to work out where it goes.
Yes. No. Well, I'll move on from that topic, Lord, in light of that. So the next point taken by Axis related to around paragraph 93 of the judgment, where the judge came back to the Reno matter. And first of all, there was reference to an email of 21st February 18. That's at tab 36 in the supplemental bundle. And what Mr. Lawrence said about this was that he criticised the judge for, quote, this is day 1 transcript, page 161, quote, doing nothing to explore the implications of the February 18 email. So there was, and said there was no analysis in the judgment what implications were to be drawn from that email. And it's certainly true if we look at 93 to 94 of the judgment, that the judge refers to the email, which does mention Reno, I accept that, of course. He says what Axis contends. He quotes Mr. Prentice's response in oral evidence, and he then doesn't say my finding on this is X, Y, or Z, but he does then go on to discuss the bills that we looked at yesterday, or the day before, sorry, and he concludes at 99 that the purpose behind raising the bills was to reduce or extinguish an amount to be repaid. It doesn't mean it was to reduce an amount of client monies that could not be repaid. He wasn't satisfied that Mr. Prentice knew or suspected that. But that's a finding that goes to the point raised at 93 and 94. But furthermore, it's relevant in our submission when considering what the judge didn't do in relation to that allegation, to look at how my learned friend Mr. Lawrence put it in cross-examination on this document. And that's in what I imagine is supplemental tab bundle 2, tab 72, page 422.
In case it's helpful, just to say our bundle 1 goes up to tab 55.
Thank you. Yes.
422, did you say?
422, milady, yes. So if we look at page 19 of the transcript here, on the top right-hand side, at line 17, there's a reference. Line 15, answer, what's the date of this email? Answer, Q, 21st February 2018. So it appears to be the email we're concerned with, as far as we can see. Then at line 3 on page 20, the question is now, Mr. Prentice, given that what you say, you've been told by given that you say you'd been told by Mr. Jones in June 2017 that the money was still standing safely in client account to Reno's credit, what did you make of this email, which clearly you did receive, which referred to a sum being owed to Reno by JSBF, which was not consistent with the money being held straightforwardly for Reno? So the question, he says, then he gives the answer the judge quotes. So it wasn't put to him that the money simply wasn't in client account, it's just it wasn't straightforwardly. And as far as we can see, there was then no analysis of the kind that my learned friend criticised the judge for not doing in the next question.
Well, bottom of the page. We were aware of Mr. Jones reacting, which seemed to be saying, these emails seemed to be saying that the Reno monies had been lent JSBF, and were therefore no longer standing to Reno's credit on client accounts. Reacting by saying to be careful, etc. And then he says, I don't know. As I said, I don't remember, I don't have any specific recollection. It's put to him squarely that the emails are suggesting the money isn't in the client account.
Only on a not straightforward basis, not straightforwardly held. In our submission.
No. Clear as day. Fairness to Mr. Lawrence. They seem to be saying the Reno monies had been lent to JSBF and were therefore no longer standing to Reno's credit on client account. That's clear. I'm sorry, I withdraw that, I accept that point. That was put. But can I go back, please, to that document? Bundle 1, Supplemental 1, tab 36, page 167. What we have at the top of this page, the email from Lauren Taylor to Mr. Jones and Mr. Prentice about subject forward Reno statements, attachments. We don't seem to have the attachments. Certainly some are redacted, the reference to them. I both, as per my previous email, please see attached the account details which I believe are required for your draft of the WP letter B. As far as I know, we don't have the WP letter that Mr. Prentice seems to have been involved with here. So again, what we have is incomplete documentation. I don't think that detracts from the point that's being made with respect in relation to these particular emails. This is probably the sort of high watermark of the case against Mr. Prentice in relation to the fact that he's faced with a document which plainly suggests that the money's not in the client account. He then lies to the court saying that he saw an internal accounting document which didn't exist, which suggested that otherwise. That's his explanation for not thinking that the monies were out of the client account. The judge doesn't accept that, but the judge doesn't actually carry further the implications to be run from all of that, and certainly doesn't make any findings in specific terms anyway, as to the I realised it was a nonsense answer. So he doesn't say, well, I accept that he's telling the truth about that. He just leaves it hanging. And that's the case that's being put.
What the judge says at 99, only 5 paragraphs later, is that he was not satisfied that in the context of the fee dispute, that Mr. Prentice knew or suspected that the reason for the fee dispute was to reduce an amount of client monies that could not be repaid. And that's similar to the point made above, to the effect. Furthermore, later on in the judgment, the judge does, admittedly in a rounding up way, say that his finding is that, this is 136 of the judgment, page 146, he makes a clear finding I do not accept that before the events of March 29, when he resigned, Mr. Prentice realised, or should have realised, that Mr. Jones had stolen client monies, or was prepared to steal client monies. I accept that in the case of the Reno matter, so expressly comes back here to Reno, taking all the material now available, even though still incomplete, and we've just looked at some incompleteness, there is every indication that client monies were misused or stolen by Mr. Jones, but not that this was in circumstances that brought that fact home to Mr. Prentice at the time, or would have brought it home to any honest person in his position with the material before him. The position was simply not clear enough then. Now, in our submission, lady, that is a finding which should not be challenged or should not be overturned on Henderson and Foxworth grounds. As I said, Volpe paragraph 2.3 says the appeal court is bound, unless there's compelling reason to the contrary, to assume that the trial judge has taken the whole of the evidence into consideration. Not all the evidence need be addressed in the judgment. Well, this evidence is referred to in the judgment. Of course, I accept there's no express finding that the judge was not satisfied on the basis of this specific email that Mr. Prentice had blind eye knowledge that the Reno money wasn't on the client account. But it's clearly implicit in his overall findings and in the way in which he carries on at the following 5 paragraphs later.
I think I'd probably be less troubled if the judge had simply stopped 136 at the words, this was in circumstances that brought that fact home to Mr. Prentice at the time, full stop. It's the following part of that sentence that I find quite difficult to digest, because if you know that there's only £3,000 left in the client account, and you know that you're being asked to inflate your hours in order to falsely inflate your hours of work in order to set off the money, it follows as night follows day that the reason you're doing that is that you haven't got enough money to pay the client.
Well, in relation to only £3,000 being in client account, that's the point that I was on a moment ago.
Yes.
And was invited to move more briskly on from. But I'm very happy to go back to it, to go to the volume of documents that were given to the SRA. The report was 295 pages long, the SRA report. Yeah. Of course, there was a clean bill of health at the end of the SRA. Excuse me a moment.
Yes, but just look at the fact findings by the judge on paragraph 86, page 138.
I'm sorry?
Paragraph 86 of the judgment.
Thank you.
Bottom of page 138. Monthly salaries are not being paid on time, and Mr. Prentice knew this. He said in his oral evidence it was reflective of the transition that the firm found itself in. Also satisfied, Mr. Prentice appreciated that Jirehouse Entities were prepared to take client monies from client account as soon as the client invoice had been raised on the client for fees. So the fact that the £3,000 figure may be buried in a large wad of accounting material is immaterial, because the judge has found that he knows that the company is in dire straits financially and is living from hand to mouth, to use the vernacular. But you say, I think, well, it doesn't matter, even if the judge is wrong, that no honest to say that an honest person in Mr. Prentice's position wouldn't have appreciated that. He's found as a fact that Mr. Prentice did not, and he's also made some findings about Mr. Prentice's moral compass, and we can't interfere with either of those findings, you say, because that's the view that he has formed of Mr. Prentice after having had the advantage of seeing and hearing him. Yes,
my lady. First of all, I'm sorry I was at cross purposes. The buried document was not the one referred to at paragraph 86. It was a different document about an account.
I'm sorry.
But which is what I was referring to earlier. But I needn't, because that's not the point your ladyship was referring to.
No. But I think that probably encapsulates, doesn't it, your position, which is, irrespective of whether the judge was entitled to find that no honest person in his position would have appreciated it, the truth of the matter is that he didn't.
Yes, and absolutely, I respectfully, if I may adopt that. The relevant question, as I submitted yesterday, was Mr. Prentice's subjective intention. That's what led to blind eye knowledge. So I fully accept that I see your ladyship's scepticism about what an honest person in Mr. Prentice's position would have thought, but that was irrelevant for the purposes of the crucial finding of fact, for the purposes of this case and this appeal. This appeal is brought on a blind eye basis.
Can I ask, page 167, tab 36, this crucial document. I have to say, I find it slightly troubling that we don't know what has been blanked out. And there's plainly something more than just the Reno Trust going on here.
Yes.
Which for some reason is thought to be appropriate that one doesn't see, but
Yeah.
I'm not at all sure that one can be satisfied that what is under that redaction doesn't have some impact upon the meaning of these emails. There's some other entity involved, not just in another client presumably, but it somehow has some effect on the netting agreement and what is owed to the Reno Trust oblique stroke somebody else.
Lord, yes, as I think I may have mentioned yesterday, but maybe not, the redaction was done by independent barristers engaged by Axis. And I certainly don't know why those matters were redacted, but I'm not sure Mr. Lawrence does either, or indeed that his
But
legal
the documents put to Mr. Prentice were in this redacted form.
Oh, certainly, that's right, Lord. Yes. And this is one of the, this could well be what the judge is referring to in terms of the lack of information that we have. The need for care in the absence of full information as to what even is in the documents that we do have because of the redactions.
Or was it? Did anyone say to the judge that if Mr. Prentice was going to be taxed on the basis that these documents showed that he had effectively a fraudulent mind in relation to these matters, that he was entitled to see the whole document, and that maybe some steps needed to be taken to protect confidentiality? But I would have been troubled about that being put to him without him seeing the whole document.
Well, the answer to the question is we did not seek to question the redaction. We did not have to invite the judge to, or Axis to challenge the basis of redaction. There was one incident I referred to yesterday, the document they produced, one of the three documents they produced after the end of closing submissions, where they informed us that, and it was the draft of the crucial letter of 22nd June 2017, and we said, well, the emails showed us a draft, where is it? You've done a word search against the word Reno, surely, if there's a draft, you've got it, and you haven't got it, and we said that casts doubt on the whole document searching process you've done, if you can't find the first draft of a crucial document like that.
But have a look at 168. Last July you sent statements of the funds held on account for something under Reno Trust. And that makes it look to me as though that there was some complexity in relation to these holdings, which at the moment I don't quite understand.
Maybe something to do with the dragonfly aspect of the transaction, because I seem to remember when we looked at the dragonfly documentation, there was another entity mentioned in connection with Reno.
That was
Wasn't that much
later,
later?
I think.
Yeah, that was later. Yeah.
It's a year later.
Sorry.
Well, there we are. If it wasn't raised, then maybe it's not right to raise it now. But I don't regard these documents as being quite as clear cut as to what they show as maybe being suggested.
Maybe that was the point that the judge was taking, really, because he does say that there's incompleteness of information.
Yes, he's certainly...
It may well be what he had in mind. My lord's very fair point.
Yes, I'm sorry, I was just looking for that where he said that. Passage I read out a moment ago. He, at points in the judgment, says, so certainly in relation to emails, for example, he says that he's unhappy with the lack of evidence. And I think, as I recall, at the very start of the judgment, he refers to lack of documents or full documents. Yes, paragraph 10, page 129. He says, paragraph 10, documents have been obtained from Jirehouse's service and from the regulatory files of the SRA. In the result, the court also has before it many documents. However, these are not complete and some are heavily redacted, apparently on the basis of claims to legal professional privilege. I'm left feeling quite sure that not all the relevant facts are known about the period of more than a decade that this case spans.
Did any witness speak as to these transactions?
There was only one witness who gave evidence, Mr. Prentice.
Oh, I can help about this. I don't know if it would be useful for me just to explain very briefly the situation, because the court is obviously interested, and I know slightly more than my learned friend, but only slightly more. First point is that neither party to this litigation knows what lies underneath the black lines. These redactions were carried out by independent counsel who were instructed by the SRA, although we had to pay for them. That's why our disclosure bill was so high. And this is all pursuant to the decision in a case called Quinn, which held, as the court may know, which held firmly that the SRA is under a duty, all concerned are under a duty to uphold and apply legal professional privilege in relation to client files held by a firm in which the SRA has intervened. That's why the redactions are there. The ultimate say was that of independent counsel instructed by the SRA and the SRA solicitors. We don't know what lies beneath. And the papers, the documents that we have and were able to place before the court were principally documents pertaining to matters in respect to which claims had actually been made against Jirehouse. And therefore, my instructing solicitors, as it were, had access to those documents. So that was the background to these redactions. I hope that's of some assistance.
Yes, well, that's what I understood to be the position, but that doesn't remove the question of what can one make from the redacted documents.
That's a matter for submissions, and I won't try to make submissions at this point.
Yes, thank you very much.
Well, my submission is that what the judge said at paragraph 10, which I've just read out, shows that he had quite clearly in mind, right at the start of the judgment, the problem to which your lordship has just adverted. In paragraph 91 on page 139 is one place where he, as we've earlier seen, in the context of the emails, expressly says, at the end of that paragraph, that he expects each of the glimpses may suffer from the incompleteness of the documents that were available by the date of the trial to the parties and the court. But he must have had in mind, as a general proposition, the difficulties with evidence in all of the findings that he had to make based on documents.
Yeah.
And in particular with the paragraph, which I'm sorry I've now mislaid, which I read out a moment ago about Reno, where he said there simply wasn't enough information at the time. Now,
the glimpses may suffer from the incompleteness of the documents that were available.
Yes.
I mean, what is, from Mr. Prentice's point of view, who of course is not my client, but the fact is he travelled from the West Indies where he now works, that's where he grew up, as a lawyer. He came to London and gave evidence. Now, he was prepared to spend 2.5 days being cross-examined by leading counsel. From his point of view, I anticipate findings that he was lying about important matters such as client money or other matters are likely to be extremely unhelpful to his position as a solicitor, as Mr. Lawrence has already said. And the judge in our submission was entirely right to be cautious about making findings that are tantamount to fraud and certainly extremely serious for perhaps any practicing lawyer on the basis of redacted, partially redacted documents or attachments that were missing.
Yes.
I think the other reference, Mr. Friendly, to material being incomplete in the Reno context is in paragraph 136.
Yes, I'm very grateful, my lady. Yes, that's in particularly as you've just said, in the context of Reno. As the Lady Justice Andrews referred to a moment ago, the last sentence, the position simply was not clear. Was simply not clear enough then.
But in the middle of that paragraph, the judge specifically says, taking all the material now available, even though still incomplete,
I'm grateful, yes. That's of course absolutely right.
There's the other aspect that, as I understand it from Mr. Jones's email, it was quite clear that the SRA was specifically interested in client account.
Yes, my lord.
And presumably one of the things that the SRA is going to do is look at a reconciliation of whether or not the client's monies are properly held on client account.
I would imagine so.
And they gave a clean bill of health.
Yes.
So isn't the judge's conclusion that 141 also well founded? The SRA investigations and reports are important. That's not to pass judgment on their quality. That is not my function. Rather than that their outcomes affect my confidence that Mr. Prentice, that had Mr. Prentice questioned or looked, he would have encountered matters, etc., etc.
Well, my lord, I would respectfully say entirely adopt that. And at paragraph, page 92 of the core bundle, paragraph 68 of our skeleton argument, we summarised this later SRA investigation. There were a number of inquiries or documents by the SRA. The first meeting, I think, was on the 17th of July, as we say in paragraph 68. All these documents, which we refer to, are in our supplemental documents bundle, but I'm not sure we need to look them up. And then at 69, the conclusion of the investigation from Mr. Carruthers of the SRA, 6th of October 2017, to Mr. Jones and Mr. Prentice, said, I have now had the opportunity to fully examine the documents provided, fully examine. As a result, I am now in a position to close my investigation forthwith and will be taking no further action.
Well, it gives rise to 2 points, isn't it? One is, it's being suggested that Mr. Prentice, who didn't carry out an investigation, should have been aware of problems which were not found by the SRA who did carry out an investigation. And secondly, Mr. Prentice knew that the SRA's investigation had resulted in no action being taken.
Which is likely to somebody in his position to be encouraging after 2 months of investigation and the 295 pages of documents being included in the full file, of which something like 80 are accounts documents.
Yes.
I mean, as I said,
but at the end of the day, all we need to find from this was that there was good material which the judge was entitled to rely on to come to those particular conclusions, which justified him coming to his overall conclusion.
Indeed, my lord. As long as a reasonable judge could have reached his conclusions, then his findings can't be overturned.
But at the end of the day, what one comes to is, however strong the points Mr. Lawrence made, and he made many strong points about the case against Mr. Prentice, there are other points which go the other way. And as you'd expect at a trial where it's alleged a solicitor had a if not a dishonest mind, certainly a mind which was sufficiently lacking in innocence,
yes.
To give rise to liability or to give rise to being unable to claim the policy. That was the issue.
That was the essentially.
And there was lots of material going either way. Is what it comes to at the end of the day.
I would
including what Mr. Prentice said.
Yeah. So in our submission, this attack on the findings of fact must fail.
Yes, thank you.
My lord, I have not addressed the next factual issue where I've touched on it is 98 and 99 of the judgment. I had said something in this context. That's in relation to the fee inflation issue, and that's really another example of what your lordship, I may say so, has just said. This is a nuanced judgment. There were findings adverse to Mr. Prentice in relation to this fee issue. The judge didn't shrink from such findings. He didn't shrink from making damaging remarks from Mr. Prentice's point of view about Mr. Prentice. As he says at 99, and I have to accept this, even though Mr. Prentice's didn't. At the end of 98, he finds that Mr. Prentice had lied in saying he didn't see any evidence of lack of integrity by Mr. Jones before March 2019. But as to that, as I said, the passage in Abiazov says it's up to the trial judge to decide the weight of lies, and he clearly had that lie in mind. And as to 99, what he finds, and this is perfectly rational in our respectful submission, is that although the purpose behind raising bills was plainly to reduce or extinguish an amount that had to be paid, it doesn't mean, and Mr. Prentice didn't know or suspect, that its purpose was to reduce the amount of client money because that money could not be repaid. Those are two different things. That's a perfectly rational approach to take. That's the finding the judge made. There's no Henderson and Foxworth error there. Now, my lord, we now actually come in the chronology of Malone and Friends submissions to the two transactions we're concerned with. I'd like to take the second one first, actually. That's Dragonfly. The judge discusses that on page 143. He sets out the details of that claim at 118 of the judgment through 123, sets out the key documents, and then says at 124, but the sequence of correspondence summarising above was not copied to Mr. Prentice. None of it was. I accept his evidence that he was unaware of the Dragonfly loan until 12th March 2019, the day before he resigned. So there's absolutely no suggestion or evidence that Mr. Prentice knew anything about the Dragonfly matter until one day before he resigned, and that finding is not challenged. And of course, at 127, the judge makes the finding about the shock that Mr. Prentice felt. Sorry, I may have given the wrong date. 15th March, 3 days before he resigned. 15th March, he resigned by email, which we have if we need it. Supplemental Bundle 2, tab 67, page 320. And Mr. Prentice at 127, line 3, his evidence is that he had a telephone conversation during that morning, during which Mr. Jones told him for the first time that monies had been paid away. I accept this evidence caused him to resign. And then at 128, he gave an account in his witness statement of his shock when Mr. Jones told him that the money had gone. This is the surplus funds money, was a large part of it. Axes say his account, the account of shock is not or that if he was shocked, it was because Mr. Jones had finally run out of room. Whilst I accept unhesitatingly that Mr. Prentice could and should have been more professionally responsible at many points in the decade leading to this point, my assessment, having seen in the witness box, is that he was shocked, and that was because he had no idea of this type or nature of misuse of client funds by Mr. Jones. There's no Henderson and Foxworth basis for overturning that finding in our submission, or explaining it away in the way that Axes suggested should be done at trial, but the judge rejected. Now, turning back to the surplus funds claim, 113 sorry, that may be a miss. Wrong reference there. I think it's 103. Yes, 103. I apologise. At 103, the judge holds that Mr. Prentice was aware of the receipt in April 2018 of the relevant funds, $14 million, as per paragraph 101 of the judgment. But at 104, he says there's no documentary evidence that Mr. Prentice knew at the time of the subsequent removal from JTL's account of US dollars 14,050,000 on the 16th of April 2018. Now, He does find, again at 103, that Mr. Prentice lied when he was cross-examined, really, by leading counsel for Axis, who flew to the United States for the purpose in June 2019, and he said he hadn't.
This was pursuant to the well-established practice that solicitors, indemnity insurers won't decline coverage until, well, before they do, they will offer an opportunity to be examined by a silk.
Yes, well, that's what they chose to do. I'm not going to say anything about that process because we challenged that, but we have not appealed the judge's decision on that, so it wouldn't be right to say anything about it. But I would say that after that interview, Axis wrote the declaratory letter which we have in the bundle, which took no point on condonation. The only case advanced, as was the case in the first version of the defence, was sham partnership. But nevertheless, of course, I have to accept that the judge found that Mr. Prentice lied to Mr. Smith when he said that he'd not been aware of the money coming in. But there's no finding, and indeed there was no basis for any finding, that he was aware of the money going out on the 16th of April 2018. What was then referred to by my learned friend in the course of his oral submissions derives from 108 in the judgment, where the judge talks about or discusses Mr. Prentice having received some emails, in particular on the 25th of January 2018, so many months after Mr. Jones had stolen the money. And this is where complaints were being made about a lack of money. And in particular, I think was referenced in the Supplemental Bundle 1, tab 50 to page 201. This is an email, probably on the 25th of January, from a Mr. Anderson. The judge actually quotes from this email in paragraph 108, the last three lines. There's nothing preventing you. This is an address, of course, to Mr. Jones, but copied to Mr. Prentice. There's nothing preventing you from making a wire. All parties believe something dodgy is going on and you're just choosing not to send the money. As my learned friend very fairly said, the context of this was emails from Mr. Jones asserting that he wasn't. Nothing dodgy was going on. I'm not proposing to go through all the relevant emails in January, but in summary, he was asserting that there were money laundering issues, that there had been trips to see counsel about money laundering matters, and he was asserting in emails, which the judge had, that, yes, 109 of the judgment, Mr. Jones suggested money laundering and compliance issues prevented the return of the money. The judge accepts those were lies, but says it doesn't mean that Mr. Prentice appreciated at the time that they were lies. And so the case put by Axis, and actually the judge discusses a number of these emails and more than the number that my learned friend quoted in his oral submissions to this court. So he considered more evidence than you've been asked to consider orally. And his conclusion at 116 is that whilst as Axis asserted that any solicitor ought, in Mr. Prentice's position, ought to have taken action and shouldn't have treated the matter as a debate between Gibson Dunn for my clients and Mr. Jones. But he holds, this is another finding of fact, 116, that in fact was how Mr. Prentice subjectively saw it. And again at 117, the reason he didn't inquire wasn't because he didn't want to have confirmed what he believed, but it was in fact due to the fact that of his instinct for self-preservation well demonstrated in the witness box, as he sought to take opportunities to distance himself from events and circumstances which would have caused him, had he realised the risk to client funds, to leave. So, my lord, it's the same point really, and I'm sorry to try not to labour this, but these are findings the judge was entitled to make. He considered the documents. There's no Henderson and Foxworth error, so there's no basis for overturning his findings of fact in our submission. So, and if I can just refer to, in the judgment, to various, I said yesterday there was a sort of theme along the lines of 117, which I've just read out. And this appears also at 34 to 35. I don't think you need to look it up in the context of his knowledge of Mr. Jones's Esquiline companies, where the judge says he was more forthcoming to Mr. Smith than to the court. At 72, in relation to the finding about making up an internal accounts document about Reno in June 2017. At 103, as we've seen, in relation to the receipt of the surplus funds money in April 18, and here again at 117. And of course, what the judge then does in the culmination of this part of the judgment is to repeat all of this really on throughout page 146, and at 139 there's another reference to this instinct for self-preservation, which really was the judge's assessment after 2.5 days of cross-examination of Mr. Prentice. And at 142, he actually quotes part of Axis's case in order to address it on blind eye knowledge. And then at 143, again states that in his judgment, the failure to look into this was not because he suspected that if he did look into this question, he might find client monies being used to meet the liabilities. So that, I'm not sure I can really add to this without extreme repetition and boredom.
What you're really saying is, what Mr. Lawrence is seeking to do is to re-argue the case.
Yes.
All of these points were firmly before the judge.
Yes.
Hasn't pointed to any real lines of document or argument which weren't before him. The judge carefully considered them and reached the conclusion that he gave that no, he didn't think that there was here blind eye knowledge. Here was somebody who, yes, he has not been frank with the court, but that's an instinct of self-preservation. And that very same instinct of self-preservation supports the judge's view that in fact he didn't know.
Yes.
Because if he had known, that instinct would have kicked in and he would have got out, as he did at the end of the day.
I can't improve on that, my lord.
That's your argument.
That's our argument.
And you say that Mr. Lawrence can show as many documents as he likes. That isn't enough to overturn the judge's reasoned conclusion.
He's got to show a Henderson and Foxworth error. That's common ground, as I understand. Well, Lord, I was then going to move on. It could be that now is a good moment, though, for a 5-minute break, because I was then going to move on to my argument.
Yes,
of law.
we'll have a 5-minute break.
I'm grateful.
Court rise, if able. I'd like to inform the court that just as yesterday, the election is still running, so we're having private conversations.
Thank you.
That's all right. I'm really pushing it myself.
sorry. Is it under here? Yeah. Thanks for that.
Quiet on
Okay,
the,
right, sorry.
if I put it here,
Yep,
is that going
that's
to be
fine.
annoying?
No, it's fine.
Yeah. Yeah, I was.
Oh, no, we haven't.
The only trouble is it's going to be below, excuse me, transcriber.
Hello.
It doesn't matter, the mic is
Oh,
under. So I move it over there. Is that okay? It's just that otherwise we'll have this.
Yeah, no, you're right. Okay, just here.
Okay.
Sorry, I don't want to be in your way.
No, it's, I don't mind where it is.
Thank you.
Thanks. About 5 minutes ago, I would say.
All right.
Thank you, my Lord. So as I've mentioned, you've had our primary submission, and it's only if you reject that submission that we have anything else to say on condonation. And I'm going to try and complete my submissions in the next 45 minutes, but if I lapse into incomprehensibility, I'd be grateful for an indication of that. I'll try and avoid it. So my first submission is that starts with the judgment at paragraph 23, page 130 of the core bundle. Here the judge was talking about condonation, and he quoted a submission of Axis's which he then agreed with at 24. Axis submit, there is nothing in the language, that's in clause 2.8 of the policy, used to suggest that it's only if a person knows of a particular fraudulent act before or at the time it's committed that he is taken to have condoned it. It is enough to know and condone a pattern of dishonest behaviour of which the particular fraudulent act forms part. And that derives from the Karim case and then applied in the Goldsmith-Williams case. And so the judge's judgment is on the footing that that is the position, that it's enough to condone a pattern of behaviour. And the summary submission I wish to make is that, objectively construed, this policy is not subject and should not be read in that way. And the reason in summary is because when you look at the Karim case, which was well known to those practicing in this area by the time Axis drafted its no doubt professionally drafted policy, the Karim case works on the basis that the word in the minimum terms, clause 6.8, the minimum terms version of condonation, which gives rise to this pattern of conduct, is the word dishonesty. And Axis decided, for whatever reason, we haven't been told, to delete that word from their policy. Yet, we would submit, objectively speaking, they must have been aware of what the Karim case said. It had been decided about 10 years earlier and reported in the leading textbook on the subject. And furthermore, Goldsmith-Williams had been reported in the Lloyd's Reports Insurance and Reinsurance in 2010, many years before Axis wrote its policy. Now, my lords, I've already addressed you yesterday, so I won't repeat that submission as to the primary purpose of this kind of insurance under the statutory scheme being to protect members of the public, but there being a policy of insurance law that those who are dishonest can't insure against their own dishonesty, and the question as to how you attribute dishonesty in the case of a corporate body such as an LLP or a company, as we're concerned with here. And the answer to that for the minimum terms is given in clause 6.8 of the minimum terms, as we looked at yesterday. My lord, at paragraph 13 of our skeleton argument, page 70 of the core bundle, we started off with a quotation which is common ground, so I needn't take you to the authority, from the Financial Capital Conduct Authority against Art, a business interruption case in the Supreme Court. As to the interpretation of insurance policies, like this one, the core principle is that an insurance policy, like any other contract, must be interpreted objectively by asking what a reasonable person, with all the background knowledge which would reasonably have been available to parties when they entered into the contract, would have understood the language of a contract to mean. And furthermore, Lord, there is in Authorities Bundle tab 10 the well-known case, and therefore I'll take this briefly, of Wood and Capita on construing contracts generally. Page 1179, paragraph 11.
Is this Lord Hodge?
Yes, Lord Hodge, yes. Paragraph
Do you
11.
need to read Lord Hodge's Wood and Capita case?
Possibly not. The only point I would make is that in striking the balance between indications given by language and indications of competing instructions, the court must consider the quality of the drafting of the clause. So if it's professionally drafted as here, the court will give less weight to business common sense and more to what the words actually mean. And it must also be alive to the possibility that one side may have agreed to something which, with hindsight, did not serve his interests.
Yes.
Now, Lord, the relevance of this is that at 128 of the judgment, page 145 of the core bundle, sorry, 129 of the judgment, the judge found, and there's no challenge as I understand it, that Mr. Prentice did not specifically approve the dishonest acts of Mr. Jones that gave rise to the surplus funds claim, and did not specifically approve the dishonest acts of Mr. Jones which gave rise to the Dragonfly loan claim. So the only way in our submission on which Access, assuming it succeeds in overturning findings of fact, could succeed is on this pattern of behaviour type submission. Now, Access's argument was based, I think, on Zurich and Karim. That's the origin of this course of conduct type reasoning. This decision of Mr. Justice Irwin. It's fair to say that at paragraph 18 of the judgment, so I'll just find that, page 130 of the core bundle, the judge referred to that decision and also Goldsmith-Williams and observed that they concerned a clause with different wording and applied to different facts. And he actually, I'm going to come to that in my next submission, but in our submission is that he was absolutely right. In summary, that in Corinne, the court accepted that the two condoning partners, who were the children of the dishonest partner, knew that flows of money out of the firm themselves could not come legitimately from the income of the firm. And in Goldsmith-Williams, the court found that before the relevant transactions, the condoning partner engaged in mortgage fraud in her own right. It was mortgage fraud that was with the relevant dishonest act, and knew that her partner did. As he said, there are not true parallels between those facts and the facts of the present case. But I'll come on to that submission in a moment, if I may. Indeed, Axis themselves, although we needn't look it up, but Supplemental Bundle Volume 2, Tab 73, page 475, para 93 of their closing submission said that Corinne was on very different facts. That's the quotation. And Supplemental Bundle Tab 2, Bundle 2, Tab 66, page 303 said, quote, that Corinne is not on point because it concerns a differently worded provision. But, presumably, they're going to say something different today. And I've already summarised my submission. The crux of the case is the wording, so let me try and make that good. And this is paragraph 18 of our skeleton argument at page 73 of the core bundle. And can I ask you to look up, Corinne, tab authorities bundle, if there are two bundles, it'll be bundle 1, tab 3, please. Unfortunately, this is an unreported case, so I am going to have to show you some of the facts, but only really in relation to my next submission, not the present submission. I'd like to ask you to turn to the third last page, paragraph 103, please. I'm sorry they're not paginated.
Mr. Flenny, while we have the background noise, could you keep your voice up?
Certainly, Lord, I'm sorry. So I was asking you to look at the third last page of Corinne, Authorities Bundle 1, Tab 3, and paragraph 103. And at the bottom of that page recites the relevant policy in that case, clause 6.9. The insurer is not liable to indemnify any insurer to the extent that any civil liability or related defence costs arise from dishonesty or a fraudulent act or omission committed or condoned by the insurer. And the point here, as I'll show in a moment, is what the judge in this case, Mr. Justice Owen, did was to read the words dishonesty or a fraudulent act or omission as he put it, as being disjunctive. In other words, he read dishonesty as being one concept and a fraudulent act or omission as being another one, either condoning either of those two things, and this is essentially the same as the minimum terms wording at 6.8 of the minimum terms, even today, even at the time relevant to our case. He read those as being two different things, and as I read it, what he said, and I'll come to this in a moment, is that if there's evidence of condoning a specific fraudulent act that gives rise to claim, that's the second limb of this wording, condoning a fraudulent act or omission, but that the reference to refer to condoning dishonesty could be and should be read as condoning a course of conduct out of which the relevant fraudulent act arose. And as I said a moment ago, the point about the Axis policy, as we'll see, is that they deleted the word dishonesty.
I'll show you what that clause means, is what must be condoned is the dishonesty from which the liability arises.
Yes, that's right, my lord. But well, that not according to Mr. Justice Owen. According to him, the dishonesty, if the dishonesty was a fraudulent course of conduct which was condoned, which then gave rise to the fraud or allowed the fraudulent act to occur, that fell within the clause. That's what he decided.
That's right.
No.
That's the last part of paragraph 108, which is the key, isn't it?
Yes, my lady. I'm grateful. So exactly, 108. The claimants also argue that there is no need for specific condonation of the particular relevant acts or omissions. That's because he found that some of the relevant acts or omissions were not specifically condoned. A number of reasons given. He says, in my judgment, however, this too is a matter of construction.
So where are you reading from now?
I'm sorry, page 108, the last page of the
Yes.
transcript. Let's start
I
at
see.
108.
Yes.
Line 3. This question is a matter of construction of clause 6.9 after consideration. It seems to me the phrase dishonesty or fraudulent act or omission committed or condoned is intended to be disjunctive as between dishonesty and a fraudulent act or omission. It says that's reinforced by B, the imputation paragraph. And he does go on to say that he's reinforced in this view by considering what the person on the underground would think. That person seems to have been in two minds because, first of all, that person would have been surprised that the contract allowed the insurers to stand aside from the contract at all. But later on, he says, and this is the crux of this line of argument, nevertheless, construing the document, it seems to me the reasonable person would be surprised if this clause allowed the insurers to step aside from those within the firm who practiced or condoned the specific forgery, but not from partners who condoned persistent, dishonest handling of money, breaches of the rules and so forth, which allowed the specific act or omission to take place. And so as I read it, what he's saying is the word dishonesty means that condoning persistent, dishonest handling of money, breaches of the rules, which allowed the specific act or omission to take place, is enough. And that was Axis's conclusion of their argument below. Now, in a moment, I'm going to submit that even if that's the law, it's not this case, even if you overturn the facts. But that's a separate point. At the moment, what I'm submitting is that reading depends on the construction of the relevant clause, and in particular, depends on the word dishonesty being in the clause, and it's not in Axis's policy, as we'll see in a moment.
Yes. It's a lot of weight to put on the first instance judgment.
In order to hold that condoning a course of conduct is enough. That's certainly, I respectfully agree with that, Lord, and that.
No, I mean a lot of weight to put on it in terms of construing the absence of the word dishonesty. Wait, you show it. Don't let me stop.
Right, I see. Well, can I show you the policy? The Axis policy, that's core bundle, tab 13, page 342. As we've seen before, clause 2.8, what's excluded is any claims directly or indirectly arising or in any way involving dishonest or fraudulent acts, errors or omissions. There's no separate concept of dishonesty in this policy. There must have been some reason why this policy is different from the wording of the minimum terms, which we have at tab 14 in the same bundle, page 375.
Well, it may be that on Mr. Justice Irwin's instruction, somebody might have been able to argue, or an insurer might have been able to argue, that general dishonesty was enough, even if there wasn't a causal connection with the act or omission, the specific act or omission. Because on Karim, he's assuming that it's the sort of background that enables the fraud to be committed. And that might be felt to be too wide, but it doesn't necessarily mean that the words act or omission are confined in a literal sense to the actual acts or omissions that give rise to the claim. I mean, what Mr. Justice Irwin decided was that he didn't need to worry about the specifics because dishonesty was enough to cover it. So I don't think Karim actually helps on the meaning of act or omission if you take the word dishonesty out.
Well, milady, I've made my submission. My submission is that on a correct reading of Karim, he must mean, he must interpret the policy to, in relation to act and omission, condonation of those to be condonation of the specific act that gives rise to the claim, and condoning dishonesty must be something else, namely, on his judgment, the pattern of behaviour. It's the word dishonesty that allows him, on his reasoning, which is expressly based on the construction of the policy, to conclude that condoning a pattern of behaviour is enough.
But the interesting thing is that I'm looking back again at paragraphs 143 and 144 of the judgment, and the judge's fallback finding on what was allegedly condoned or not condoned. He says, even if, contrary to my finding, Mr. Prentice is suspected that client monies were being used to meet firm liabilities, the suspicion would have been a suspicion about the use of them to address temporary exigencies and not a fraud of the nature and scale that involved in surplus funds. And then he goes on and says, in 144, he didn't condone Jones acting dishonestly or fraudulently. If he did, then what he condoned was the use by Jones of client monies to address contemporary exigencies and pressures. These acts were not the acts involved in the claims. So, on the judge's alternative case, he's finding in your favour on the construction point, despite the fact that he said something different earlier in his judgment.
Well, he's expressly rejecting the argument I put to him, which was the same as the one I just addressed to your lordships and your ladyship. I'm sorry. He did reject that in turn.
He rejected at the earlier stage, but then when you look at this later stage, he appears to be looking at the facts and suggesting that if it had been made out by Axis that there had been dishonesty in the sense of condoning the use of client monies to address temporary exigencies, that wouldn't be good enough.
Yes, but he could be interpreting that in light of what he says at 23 and 24 as meaning it's not enough. At 23 he accepts it's enough to know and condone a pattern of dishonest behaviour of which the particular fraudulent act forms part.
Yes.
So it could be that in the passage my lady has referred to, what he's really saying is
that's not part of the
this
pattern.
is not.
Yes.
This is not a pattern of dishonest behaviour of which the particular act formed part, because temporary exigencies are not part of a pattern of regular misuse of large amounts of client money.
Yeah.
I wonder if there's slight ships passing the night here. I don't read the judge's construction or analysis of a broader scope of condonation, saying that it's enough, it was condonation of broader dishonesty. What I understand him as saying is that if there is a pattern of which these fraudulent acts form part, you have condoned these acts.
Yes.
Not that you haven't condoned these acts, but you have condoned them because, as we discussed earlier, I can't remember if it was Mr. Lawrence, somebody may well condone something generally without necessarily being aware of specific issues. You can give approval to a course of conduct or a pattern of conduct without knowing specifically when, where, and how, and in what context each of those acts is taken. And I understand the judge to be, that's the judge's holding, and what he says at the end of his judgment is, well, even if I'm wrong about blind eye knowledge, the matters of which are alleged that he did know about aren't part of a pattern. So he doesn't know about these specific fraudulent acts. So he didn't condone these specific fraudulent acts.
Yes, I would respectfully accept that, my lord. I mean, his primary finding is on the facts. That the blind eye knowledge is just not made out. Yes. And so it's only if you overturn that finding that we get into this question at all. If you overturn his finding, then I suppose we are into his fallback. He expressly calls it a fallback. So suppose he was wrong about blind eye knowledge, he would still say that as I read it, that insofar as there was blind eye knowledge, it wasn't blind eye knowledge of a consistent pattern that amounted to condoning these two fraudulent acts of $14 million on the one hand and just under £5 million on the other hand.
Because what he might have been condoning was dipping into client funds for a temporary exigency,
Yes,
but he wasn't condoning whole-scale fraud.
precisely, lady. Yes, that is the judge's fallback position. If he's wrong about the facts, I would accept that.
Yes.
I've made my submission on that.
Yes.
There's slightly more to it in the skeleton, but not very much. I think your lordships and your lordship and my ladies have the point I wish to make on that.
Yes.
Unless I can, on that particular point.
I think what's really important is that you deal with aggregation.
Right. In that case, I'm grateful. Can I then refer to paragraph 19 of our skeleton argument? And that's on the point that even if I'm wrong about both of my last two submissions, actually when you look at the facts of Goldsmith-Williams and you look at the facts of Grim, they are very much more serious than the facts of this case. And so even if there was a pattern there that was condoned, there isn't a pattern here, even if you overturn the findings of fact.
Well, you've got a finding by the judge that there isn't a pattern here, so you don't really need to start looking at other cases, do you?
Only if you overturn his finding. If there's no risk of you overturning his finding, I'll move swiftly on.
Well, it's a matter for you, Mr. Fenley, but Mr. Lawrence took almost just about half his time on aggregation.
Yes.
And
yes.
And you're going to allow yourself something like 25 minutes, and
yes,
it's a matter for you. But I thought we certainly would like to hear you on it.
Certainly, my lord. Well, can I then, having referred for my other submission at 19, just ask the court to note that and the points made there, which I certainly don't withdraw.
Yes.
Move on to the question of aggregation. So this relates to clause 5.2, of course, of the Axis policy, tab 13 of the core bundle, page 349. As we've heard, the reliance on B and C is now abandoned, so it's only E, 5.2E, that we are concerned with. And the wording is similar acts or omissions in a series, of course, of related matters or transactions. And as we'll see in a moment, this is common ground, the Supreme Court in Woodman, AIG in Woodman, has held that those are two separate requirements. Both have to be satisfied to come within this clause. So I'd like to take similar acts or omissions first. As to that, the only authority I'm aware of, and that was referred to at trial, is Woodman, AIG and Woodman at first instance. That's Mr. Justice Tier, tab 6 of Authorities Bundle 1, if there are two authorities bundles. And the relevant page is 151, going on to 152. It says at paragraph 28, bottom of column 2, the claims must arise from similar acts or omissions, although there was some dispute between the parties in the SRA, must arise from. I was told there's no need to resolve that dispute. What I have to do is determine whether the claims arose from similar acts or omissions. No dispute that acts or omissions are similar if they bear a resemblance or likeness to each other without being identical, nor there was any dispute that at one level of abstraction, labelled very high by counsel, the acts and omissions were similar, but at a lower level, when one had regard to what they had actually failed to do, their acts or omissions were said to be not similar but different. At what level should one judge similarity? The clause doesn't give any express assistance. It's the same clause, I believe. Court must decide what's implicit in the clause. The aim or object of the clause is to permit claims to be aggregated for the purpose of applying the limit of the insurer's liability per claim. Different aggregation applies to retention. The requisite degree of similarity must be that which is appropriate, having regard to that aim or object, so per claim. In deciding what that degree is, the court can't rewrite 2.5. Faithful to words, he holds that the requisite degree of similarity must be a real or substantial degree of similarity, as opposed to a fanciful or insubstantial degree of similarity. This is not adding words, rather construing similar. And if we look at how he applied it on the facts of this case, which we've already looked at, in all the claims, both those with regard to Peninsula Village and those with regard to Marrakesh, a local Midas company couldn't pay the vendor, in one case the vendor of land, in the other case the vendor of shares. In those circumstances, defendants, solicitors, failed to provide effective security, in one case over land and the other over shares, so the test for security investors, I believe, was not properly applied. So after the investors' monies had been released, the investors were exposed to loss in the event that developments failed. There is a real and substantial degree of similarity. It's neither fanciful nor insubstantial, so the clause is made out. Now, my lord, in relation to that, we summarised in our skeleton argument at paragraph 6 and 7 the essential facts. This is page 67 of the core bundle, essential facts of the two claims. So paragraph 6 is about the surplus funds claim, reading from line 4.
Forgive me, which tab?
I'm sorry,
Tab 4,
great.
page.
Tab 4, page 67.
Thank you.
Reading from paragraph 6 and line 4, these are the essential facts of surplus funds. On the 13th and 16th of April 2018, one of my clients sent a total of $14,050,000 US to the Jirehouse Entities for the purposes of the purchase, to be held on trust for the first or second respondent. But the same day, Mr. Jones dishonestly authorised the removal of that money from the bank account of Jirehouse. And that's the basis of the claim, really, that that money was withdrawn. It's fair to say that's not pleaded out in full in the particulars of the claim we looked at, because that wasn't known at that time by those acting for my clients. But that's what we can now see, that's what the judge says happened. So that's simply taking money from client account wrongly, on receipt. It's really as simple, from the point of view of the claim, as that. Solicitors hold money on trust for clients. Removing it for a purpose that's not authorised by the client is a breach of trust. My lord, so far as...
Well, what has to be similar are not as it were, the legal characterisations of what's done, but are the acts or omissions.
Yes.
I mean, in a sense, we're always going to be dealing with acts which are breach of duty.
Oh, certainly, yes. It can't be just
So,
both breach of duty.
It can't just be breaches of duty.
No.
You have to look at the acts or omissions.
Yes.
And here, the act or omission is the unauthorised removal of monies from the client account by way of dissipation.
Yes, the breach of trust.
Yes.
And the
What?
failure to use it for the purpose for which it was intended. You've got the two together. They're
Yes.
the two sides of the same coin.
Yes, I'd certainly accept that. It's essentially taking the client's, authorising the removal of the client's money and then not giving it back, as you could say. So it's not using the money for the purpose for which it was given by the client to the solicitor and for which the solicitor holds the money on trust. The trust, terms of the trust being to comply with the client's instructions.
Yeah.
And we can now see in this case, it's what you know, Mr. Jones is in jail for a number of years following a private prosecution by my clients, since the CPS, I think, weren't interested. And the judge's findings, it's quite clear that he dishonestly removed the money.
What was he actually convicted of?
Two counts of fraud, both in relation to the surplus funds claim.
2 counts of fraud
Yes.
under the 2006 Act.
Yes.
Yes.
So the act that gives rise to the claim is authorising the removal of the money. in circumstances where there was no intention to give it back. And as I said yesterday, because it's a claims-made policy, it's the act that gives rise to the claim. In our submission, you must focus on in applying this clause, because the policy is all about claims. That's what the insurance clause says. Insuring clause says it's a professional indemnity policy, so it's concerned with claims against the insured party.
Yeah. So in contrast,
paragraph 7, the Dragonfly loan. So this is, of course, months later. The castle is purchased. It's transferred to the third respondent, River Tay Castle LLP, and between 21st January and 11th February, Mr. Jones defrauds RTC of further sums by, without the knowledge of RTC, causing the castle to be charged to Dragonfly. Dragonfly pays Jirehouse £4.9 million, and Jones then dishonestly authorises the transfer of that sum away from Jirehouse. So that, in our submission, is not similar in the sense that the transactions were similar in Woodman, where presumably there was no appeal at this point from Mr. Justice Tier. In Woodman, it was broadly the same failure by the solicitors failing to get security, but happening over and over again. And one can see why insurers might want to say, well, let's suppose one has a negligent solicitor who's a very hard-working person, handling lots of high-value transactions and keeps making the same negligent mistake over and over again. That gives rise to many very similar claims. One can see that insurers might want to say, well, that's really something we should be allowed to aggregate, and even if the precise errors are slightly different but fairly similar, we should still be able to aggregate.
well, just remember, let's break this down. Your paragraph 7, going over onto 68. Mr. Jones then dishonestly authorised the transfer. So that is the same, not just similar, but that is the same act or omission as as was complained about in relation to surplus funds. So to that extent, it's not just similar, but it's the same act.
I would accept that, but that's not enough to give rise to the claim, because the claim arises from his... I'm sorry to interrupt.
No, you can't.
The claim arises, could not have occurred. The money couldn't have been removed unless there'd first been a mortgage, which he dishonestly...
Well, that's factually right, but you're not right to say the claim wouldn't have written. You say the mortgage had been authorised by your clients. You still have a claim for the dishonest transfer away of the monies.
You would in that case, but the question here is, are the acts and omissions, or omissions in this case, be it acts, which gave rise to the claim, similar in relation to both Dragonfly and surplus funds? And in our submission, you've got to look at all the basic, you don't have to go into great detail, but the basic acts which gave rise to the claim, and that must include procuring, without authority, the taking out of a mortgage.
Can we frame the question more neutrally? Both frauds involved the theft, unauthorised by the client, transfer away of the client monies for the benefit of the solicitor personally.
Yes.
So the question is, does the prior act of having obtained those monies by an unauthorised mortgage mean that it is not a similar act? And that's the question at the end of the day, isn't it? Does a prior step to obtain the monies in the first place mean that the act is not similar? The acts and omissions are not similar?
Yes, I would accept that. A prior step, which is an essential part of establishing the cause of action.
Well, again, I'm afraid I just don't accept that. You'd have had a complete cause of action. You need not have relied upon the fraudulent obtaining of the mortgage. You could have said we're quite happy with the mortgage, but he stole the money that was raised. So I don't think it is an essential element of the cause of action. I think it is an additional element that you can rely upon. But in fact, if if the monies had been obtained by a fraudulent mortgage but had sat there for the purposes of development, your clients would have had a complaint that the monies had been raised, but they wouldn't have had any. They wouldn't have had any financial remedy if the monies were sitting there.
Well, they'd have an exposure under the charge, wouldn't they?
Yeah.
I mean, it's our submission that both elements were part of this claim, and that the court should look, as the judge looked, at both elements as part of this claim. If one looks overall at these two claims, were the acts remissions which together gave rise to the two claims all similar? No, they weren't, because on the case made against Dragonfly, one element was fraudulently causing the mortgage. If there'd been no mortgage, there would have been no money to steal.
Well, the other way of looking, I mean, again, you can cut these things different ways, can't you? And the other way of looking at it is that Mr. Jones raised monies from your clients in two different ways with the intention of stealing them. One was for the ostensible purchase of by saying you needed purchase monies to purchase the property, and then even more monies to purchase the property, which were then stolen. And the other was by raising monies from a mortgagee, which were then stolen. So, I mean, how different is it really at the end of the day?
Well, it's certainly true that if you move to a great level of abstraction, then of course everything is similar. But it's our submission that it would be, an incomplete description of the Dragonfly claim to simply say money was removed from the client account. Part of the reason why the money was there in the first place was the taking of an unauthorised mortgage.
Do we know whether it ever went into the client account from the Dragonfly? What we got? You said it paid Jirehouse for 4.9 million, which is secured by the charge.
Yes.
Did it ever go into a client account?
Yes, it did. Excuse me a moment.
Yes.
I
I only asked that because there were a whole series of different Jirehouse entities involved at different stages.
Tab 59, Volume 2, Supplemental Bundle,
Yeah,
page 246.
tab 59.
So that, I think I'm right in saying, shows on the 11th of February 2019 the money coming in from the borrower's solicitors Howard Kennedy, £4.9 million, and on the 12th of February 2019 going out allegedly by way as a loan to EML, which was a company certainly connected with Mr. Jones. So it is right to say it went into and out of
The client account.
the client account of Jirehouse General Client Account.
Yeah, thank you.
But certainly, in our submission, any attempt to articulate Dragonfly claim would inevitably have involved setting out the circumstances in which the charge was wrongly obtained.
What if the charge hadn't been wrongly obtained?
Well, it was authorised by Mr. Clark, as I recall it, without the knowledge of those who actually owned River Tay Castle.
But you don't submit against Dragonfly that it wasn't an authorised loan.
Well, we pleaded that neither of the first two respondents consented to Jirehouse procuring the River Tay Castle to enter into the facility, or to grant the charge, or to draw down any money under the charge. Neither Mr. Clark nor Jirehouse had authority to sign the facility nor the Dragonfly charge, or arrange or execute them or draw down any sums under the facility.
What he's done, let's just stand back and look at it at the moment from a practical point of view, is he's used the name of a client or a client's assets to procure money from a lender secured on those assets for himself, effectively. So it's not just a simple case of dipping your hand into a client account and taking the money out. What he's done is he's used the clients as a front, if you like, for getting the money and passing it through the client account and then taking it. And that does seem to me to be somewhat different in character from simply helping yourself to client funds.
Because client ends up with a charge, which has to be repaid.
Yeah.
So it has a liability. It's not just it's lost its own money, it has a liability to a third-party lender. So the characterisation in our submission, the judge's valuation was right. But when you look into the detail, from a fair and objective view, which we accept them to be,
I think one understands the distinction in the argument. I'm just quite anxious that if you do want to, you have a chance to say something about series of related.
Yes, I'm grateful.
Because in fact, that was, I think, the point that Mr. Lawrence focused on more than the similarity of the acts or omissions.
Yes, that's true. I focus more on act or omission. I submit that the judge's finding was right about act or omission, and that's enough.
Yes.
There was no.
But you don't. But you don't abandon the other point, do you?
No, I don't do that. Although covering it in 6 minutes may be challenging. And I'm sorry about that. But let me turn, if I may, to AIG in the Supreme Court, which is Authorities Bundle tab 9, probably in bundle 2 if there are 2 bundles. And relevant pages are 1174 onwards. And again, my submission is that the judge's evaluation of this was not plainly wrong, and in particular with regard to this exercise, as Lord Tilson says at page 1175, between B and C, determining whether transactions are related is an acutely fact-sensitive exercise involving an exercise of judgment. So in our submission, you'd have to find the judge was plainly wrong in order to overturn his finding, or sorry, his decision, perhaps is a fairer term. And he obviously had Woodman in mind because he quotes it, Supreme Court's decision at 158 of the judgment. And he holds that the matters did not fit together. That's a reference to the test, I'm sorry, I'm just looking for, of Lord Tilson.
Well, there was a criticism made. There was a criticism made of the judge that he hadn't quite got the test exactly right because the test must in some way fit together. What do you say about that?
Yes, I'm sorry. I'm just trying to find the fitted together language I failed to do. I'm sorry.
Do you mean in Lord Tilson's?
Yes, I do.
I think it's at the top of page
Yes.
1175.
Yes, I'm grateful. Yes, it's between letters A and B.
Must in some way fit together.
But then, if you look at how he applies that test, he looks at legal factors as well as factual factors. For example, over page 1176, letter B, he talks about the legal structure being similar in relation to 2 categories. So he looks at legal structures, as I say, 1176 between A and B. That is a relevant factor. So the judge was right to take that into account. His evaluation wasn't, in our submission, plainly wrong. he says in 158 of the judgment, and this is really going back to the point we've just been discussing, that the theft of the money in surplus funds didn't depend on a loan, while Dragonfly did depend on a loan. And so in that sense, they didn't fit together. There wasn't a legal structure. In the case of Woodman, there were two developments, tourist developments of properties, and as I recall it, there was one legal structure per development. And Lord Tilson says they aggregated by development because the developments fitted together. Everyone investing in one development had similar documents. They were investing in relation to a similar site. The legal structure was the same. They were all signing up to the same, no doubt, set of contracts, no doubt very similar. But here that was not the case because, at least in our submission, the judge was entitled to find that the legal structure of what was done in order to extract the money under the Dragonfly loan claim was different from that in relation to the surplus funds claim.
I think what is said against you is that the overall project of the castle was to buy the castle and do it up. And so the purchase was an essential first step in that overall objective, and the loan was another step in the same with the same objective, and therefore they fit together in the sense that you have to buy the castle before you take a mortgage out on it to raise finance in order to do the development, and therefore it can't be said that there's no, in some way, interconnection between them.
Well, I'm not sure there is any finding that there was an intention to raise the money under the Dragonfly loan. That money was raised essentially by Mr. Jones in all his own purposes.
Yes, but he dressed it up as being part and parcel of a bridging loan in order to raise finance for the development of the castle.
He dressed it up in that way.
Yeah.
They didn't fit together in the sense that it was fitting together in Woodman, because in Woodman, everyone was subscribing to the same, as I recall it, the same contractual structure. There was one company or one mechanism of investment, in one case a company, in the other case buying land, per development. So for one development, everyone had to buy shares in the company. The other development, everyone had to buy little bits of a parcel of land. Those two aggregated, but they didn't, between themselves, but they didn't aggregate together. Now, you can buy a castle without needing many months later to, with different parties, to engage in a loan. After all, the loan wasn't raised as part of the purchase money of the castle.
Yeah.
Again, on a higher level of abstraction, it might be said that your clients had unfortunately allowed themselves to get into Mr. Jones's clutches, and at that point he was then able to, using his role as solicitor, having set up the structure, to take monies from your clients in various ways. And he did it by taking the purchase price, and he did it by taking mortgage money.
Yes, well, you certainly could put it in that way, but as Mr. Lawrence showed you in the Woodman case, the widest factor wording is one same originating cause. I think that's Lord Muston's phrase, and that expressly was not used in this case. Clearly, if that phrase had been used, then the originating cause, the cause would be Mr. Jones being dishonest. But that's not this clause in our submission.
Yes. I think you have run up against your promised time limit. You have much more to say.
Yes, I would like to refer then simply to 109C of Access's skeleton, which I submit does not put this case on the basis the loan was my client's intention. It puts on the basis it was Mr. Jones's idea. But I've run up against the time limit, so I'll sit down.
Thank you very much.
Well, just as to that last point, just for the court's reference, the email that I went to in opening,
Yes.
clearly shows that my learned friend's clients were contemplating
Yes.
what they call project debt or project development is unagreed bundle tab 17. That's the email from Mr. Hinkle on the 7th of January 2019.
Yeah.
So
We have that from your opening.
exactly. Well, I just wanted to make that point. Again, a short, granular point in relation to aggregation, which my learned junior, who is more than that, has brought to my attention, arises in relation to the Woodman or the AIG decision at first instance. It's a small point, but I do want to just make it. That can be found, that decision of Mr. Justice Tier can be found at tab 6 in Authorities 1. Has that, the court will see from the head note, right-hand column, 7 or 8 lines down into the second paragraph, the investors fell into a number of categories. Those who lent money to the Peninsula development, those who lent money to the Marrakesh development, and then, reading down about 5 lines, semicolon, those who had paid money to purchase holiday homes, and so forth, and then reading down, and crossover beneficiaries who had originally entered into loan or purchase agreements, but then moved from Turkey to Morocco, as it were. And just developing that point very shortly, if the court could kindly turn to page 150 of this report, paragraph 17, several causes of action are relied upon. In the amended particulars of claim, the claims of those who loaned money are put in negligence and breach of fiduciary duty, and the claims of those who paid money to purchase holiday home are put in misrepresentation, breach of the escrow agreements, and breach of duty as trustee. There were, accordingly, differences between the positions of various different investor claimants in that litigation. But in the event, those differences ultimately were not regarded by the Supreme Court, and in relation to similar act or omission, not regarded by Mr. Justice Tier as leading to a conclusion that the claims or some of them should not aggregate. My Lord, my Ladies, I will, in time I have available, I will deal, having taken quite a long time on it in opening, I'll deal very shortly in reply with points that arise on aggregation, because the court obviously knows the substance of what I say about aggregation and the matters that I rely on. In relation to the first stage, namely, were there similar acts or omissions, I do fasten on my Lord's observation that on one view of the matter, the relevant act, namely theft from client account, was not similar, it was in substance the same. My learned friend's response is to say, well, maybe, but one has to look at the prior act, which was the set of, no doubt, deceitful representations that led to the charge being executed and the monies being raised on a false basis from I know that my insurer clients would very much want me to make this point, and I will make it. I respectfully submit it's a fair point. Namely, that this aggregation clause is designed to operate in the real world by reference to real claims and real liabilities. To borrow a term from the law of defamation, one needs to look at the sting of what is really being alleged against the defendant in this type of position. And the sting of what is being alleged, and that which caused the substantial loss, was the theft from client account. True it is that there could have been a different, much less significant claim relating to what one might call unwinding costs in relation to the deceitful taking out of a loan, even if the monies remain in client account. But that's not what this case is about. It's not what my clients have to, arguably, have to insure, have to cover, pursuant to the insurance policy. So
Well, but indeed, and I understand. I did put that point to Mr. Flenley.
Indeed.
But isn't the broader point here that the mortgage was taken out with a view to immediately stealing the monies? So you can break it down, but isn't the real world. The real world was that these monies were never going to sit in the client account to be and then later stolen. This was a mortgage which was obtained for the fraudulent purpose of Mr. Jones taking the money. So forgive me, the argument goes one way, but it can be put, as I think my lady put it, to Mr. Fenton.
well, this fraudulent individual did use that methodology to get the money into his client account. He then stole it. It was the theft from client account which caused the substantial loss which underlies the claim. And my clients really, I don't want me to say, and I do make this submission, that effectively they recognise that this court must apply, approaching the matter, the construction issues neutrally for all the reasons that have been canvassed, must apply the words of the policy. And if the words of the policy relating to dishonest acts and condonation do not meet this case, then they and others will have to reconsider their position. So be it. The court has applied the words of the policy. In relation to aggregation, I do submit that we are asking this court simply to apply the words similar and related, not the same in either case. And in relation to similar act or omission, the similarity, the court has my submission, the similarity consists in the fact that on each occasion, Mr. Jones was stealing a certain client's money and was unable, as it happens, he was able to get his hands on that money because of the fact he was acting in relation to the Taymouth Castle transaction. I can't expand or improve on that submission. It's a very straightforward submission. In relation to stage 2, namely, are the transactions related, I will just bring the threads together in this way. Either they were related, obviously there's a de minimis exception to that, but either they were related or they were the opposite of being related, which means unrelated. And if one asks oneself, was the Dragonfly fraud unrelated to the fraud that was committed in relation to the purchase monies? I do respectfully submit, for all the reasons I sought to give an opening, that the answer to that question is clearly no, they weren't unrelated, those two matters. They were related for the reasons that I've already given. And then, stepping back and using a metaphor that my lord used on the first day of this appeal, web this was, dishonest, deceitful, dangerous and expensive web this was, that the claimants, one economic unit as the court knows, the claimants found themselves in when they chose, unhappily, to instruct Jirehouse to act in relation to Taymouth Castle. They were in the web, and my insurer clients wish me to submit that this aggregation clause does indeed provide them with limited protection that it does, where
we assume that everything you say is something your clients wish you to submit.
Well, I cross my fingers, but I hope so. Indeed, but my lord will understand.
Yes, I understand.
The nature and purpose of these submissions. The only last point I would make on aggregation is this some weight, a small amount of weight, I think, on the other side of the court is attached to the fact that the purchase monies were stolen back in April 2018. There was quite a long temporal gap between then and the Dragonfly fraud, which did follow shortly after the completion of the purchase.
No.
I respectfully submit as to that's a matter that should not weigh with the court when it applies the aggregation provision. It's an odd feature of this case that the purchase monies were paid into Jirehouse's land account where they should have stayed. many months before completion. That's abnormal. We don't know why that was. There must have been a good reason for it, but it is an odd feature of the case. But my submission is the answer to the aggregation issue in this case is would not be affected either way if the purchase monies had been paid in the normal way in October, say October or November.
It's not the timing of the payment into the client account, it's the timing of the theft, Mr. Lawrence. The theft occurred long before Dragonfly was even a glimmer of an instance in the mind of Mr. Jones.
Absolutely, my lady, I fully accept that.
That's the point. The point about timing is nothing to do with the timing of the payment in of the monies, it's to do with the timing of the theft.
Yes, well, the two are obviously connected.
Yeah.
One knows that Mr. Jones, the moment the money came in, the money was going to leave. But I fully take your ladyship's point. Come back to the fact that it was all Taymouth Castle fraud. I won't repeat that submission. I need to make some short submissions in relation to condemnation. Unless there's any other point or question that the court would like me to seek to address on aggregation, I shall move on.
Well, can I just one point?
Please.
Is that we've looked at obviously the similar acts for omissions test, and we've looked at the word related transactions, that phrase, but we haven't actually focused on the word series. And it seems to me that you can't ignore that, and what you're looking at has to be a series of related acts. Now, I mean, I can understand one could say, well, if you have more than one of them, it's a series. It seems to me it may import a little bit more than that and give some meaning, some added meaning in combination with related transactions. What we're looking at is a series of related transactions. And can you say that the purchase monies, the payment in of purchase monies and unauthorized payment out, and then many months later, the obtaining of a mortgage and payment out of those monies is a series of related transactions? I think that phrase doesn't immediately seem apposite to those two quite disparate acts in both time and content.
Well, Lord, I respectfully submit that the answer to that is you certainly can say that. Series goes back to, etymologically, it goes back to a word that's connected with follow. One thing follows another, as I recall. And obviously there needs, for it to be a series, there needs to be some underlying connection. But my respectful submission is that the presence of the word series in that clause, in practice, adds very little to the concept of relatedness. If you have one transaction following another, where the second transaction is related in the relevant sense to the first, it is, I submit, difficult to see. There might be extreme cases where this would apply, but it's difficult to see why that would not be a series. A series is, the term series is not a very, it's not a term that is difficult to apply to a sequence.
Yes.
In that way. Doesn't add much to the word sequence, is my short submission. Turning then to condemnation, which I shall obviously address shortly in reply. First, a very short submission, and I'm sure unnecessary really, but I'll just make it so that the court knows exactly how we respectfully ask the court to approach this matter in terms of appellate procedure. At one point yesterday, my learned friend suggested that I had abandoned a certain matter because I had not mentioned it in oral submissions, but I expect he misspoke very uncharacteristically. Of course, unless I expressly abandon something that is in my skeleton argument, I have not abandoned it. I have abandoned, or to use the politer expression, as Mr. Prentice would say, chosen not to pursue the two aggregation limbs that I have dropped. But otherwise, the arguments in my written skeleton are the argument on this appeal, supplemented by the various matters that have been canvassed in oral submissions. That's the way, as this court, of course, knows, that's the way it works. And my learned friend, the skeletons were provided sequentially, and he's had the opportunity and taken it to answer what we say in our skeleton at considerable length. as it happens in this particular appeal, we applied for permission to serve a skeleton that went beyond 25 pages and obtained it on the basis that in circumstances which at the same time the relevant Lord Justice Males, reduced the time for oral argument from 3 days to 2 days. I've been proceeding at some speed, excuse me, at various points during my oral argument, and that is why. And so, in those circumstances, I respectfully submit, I'm sure unnecessarily, that it's very important that the court.
No, you can take it that your arguments, unless abandoned, which appear in your skeleton,
Thank you.
Are your arguments on the appeal.
Absolutely, absolutely, my lord. Thank you very much indeed, and therefore everything in the skeleton is as it were, in play. Now,
What's the particular matter that you're saying that Mr. Flannery wrongly said you'd abandoned?
he used the term abandoned, I think, in relation to the matter on which I place, it happens very little weight, which is the defamation action settled by
in
in 2014.
You didn't address us on.
I didn't address you on that. I don't attach very much weight to it, but I just took issue as a matter of principle with the idea that I abandoned something because I hadn't mentioned it. I know the court would not suppose that. Lord, my own friend addressed you on two critically important, as it were, sections in the judgment, and those are the sections that run between, in particular, in the first place, between 93, paragraph 94, through to paragraph 99, and then paragraph 135, stroke 136, 137, through to 136, and then to 143. And I'm going to respond briefly in relation to those. Can I set the scene for my responsive submission in relation to those parts of the judgment by noting that at 2 points yesterday, my learned friend could not resist temptation and had a little bit of a dig, if I may put it that way, at the at two. I won't put it that way. He gently criticised two important findings, primary findings of fact that the learned judge had made. They were, first, the important finding that Mr. Prentice had made up a story about being shown an account document that proved that the Reno money was held on client account. I'm trying to remember now the second matter. What's the second matter? Come back to me. Yes, the second matter that he engaged a little bit of criticism in relation to was the set of adverse findings concerning the late 2006 episode relating to the winding up petitions. Well, a friend said in passing, well, some aspects of the relevant criticisms were not pleaded, but we decided in the end not to advance on appeal an argument that because those matters hadn't been pleaded, they could not properly be the subject of adverse findings. Now, of course, he didn't seek to develop those points because he has not cross-appealed in relation to those primary findings of fact. But I just pick up the fact that I draw attention to the fact that he did not restrain himself from criticising aspects of the procedure that the judge took in relation to those matters, because what that reflects is that, I may put it this way, we won this case in relation to the primary findings of fact. As the court knows and has observed rightly, I have consciously, deliberately and advisedly not taken the court to large swathes of cross-examination because I am quite sure that it would not assist the court in any way. We won on all the big primary issues about what happened in late 2016, about Reno, even to some extent about the strange passivity and inaction of Mr. Prentice in relation to the the developing crisis concerning Taymouth Castle. We won on all of that. We won also on issues as to whether Mr. Prentice had read documents which showed that the Reno monies had gone. So while I went to those documents, I did not need to take up time looking at the underlying material in detail, and just for the court's note, the judge's finding as to the reading of those documents are to be found at paragraph 62 and paragraph 93 to 94 of the judgment. So I simply give your lordships those paragraph numbers, which will, paragraphs themselves, will be very familiar if the court were to go back. I'm sure it will, and look at them again. We won on all of that. But we didn't win overall, which is why we are here. We are appealing. And the tale is told. I can encapsulate the real issue that we are asking this court to address on condonation by inviting the court's attention to page 146 of tab 7 in the judgment. The court is very familiar with this part of the judgment. Paragraph at the top of the page is the one that I went to yesterday morning. That certainly looks and is very favourable to the case that we were advancing, in that it makes the findings it makes about Mr. Prentice, realising that Mr. Jones was up to no good, being compliant and being prepared to turn a blind eye. The further paragraph, which at first sight looks to be very promising from the point of view of the party alleging condonation, is 2 paragraphs down, 137, where the judge holds, as he does later, that Mr. Prentice was not suited to be involved in a legal practice. Now, just pausing there and taking stock, and for a moment considering this case and this situation from the point of view of an insurer who has agreed to provide cover subject to the dishonesty/condonation exclusion. An insurer might, and I would submit fairly, say in relation to those findings at 135 and 137, this is a situation which it is clear from the terms of the policy we did not intend to provide cover in relation to, because you have a major fraudster in the form of Mr. Jones, and you have the only other partner who owes the wide range of supervisory and reporting obligations, particularly in relation to client money that he owes, being found to be somebody who should never have been a solicitor in the first place, and somebody who's turned a blind eye to improper activity.
I'm not sure how looking at this through the subjective viewpoint of the insurers takes it any further.
Well,
and we know what the insurers agreed to do and the exclusion that they put in.
Yes.
And it's the job of the judge to determine whether or not that exclusion was made good on these facts. And the insurers may well be unhappy with the outcome, and the fact they're here demonstrates they're unhappy. I'm afraid that doesn't really cut much ice.
No. I fully understand.
If we allow the appeal, the claimants will be unhappy. So
absolutely. A plea to the court that is based simply on the fact that my client will be unhappy if it continues to lose on condonation is obviously not going to gain any traction at all. I was seeking to make the submission that as a matter of a robust, commercially sensitive construction of the policy, one can see the force of the argument that the policy is not designed to compel insurers to cover this sort of risk where partner number 1 is engaged in major fraud, and partner number 2 is turning a blind eye to bad things and for good measure should not have been a solicitor in the first place. But perhaps the policy does have that effect, and that obviously is the issue.
well, the reason when I read 137 is
yes.
one of the things the judge is saying is he shouldn't have been a solicitor, and one of the reasons he shouldn't is that he ought to have been aware of what was going on, but he wasn't.
Yes, well, indeed. Now I need to, having made my possibly unappealing cri de coeur on behalf of my client, I then need to seek to identify what it is in this part of the judgment that we criticise and challenge on this appeal, and say that we can permissibly do that, having regard to all the principles about appellate restraint that have been discussed and very familiar to the court. We lost, and the reasons we lost in this part of the judgment are demonstrated, first of all, by paragraph 136, which my learned friend very, very fairly has placed weight upon.
Yes.
The court knows what that says. It could be said that paragraph does not fully or quite entirely correctly state the test for blind eye knowledge, but I don't expect the court to place any weight on that at all, because it is clear, reading the judgment as a whole, that the learned judge did have that test in mind. And we lost also by reason of the more widely expressed exoneration of Mr. Prentice in relation to condemnation, which is at paragraph 143 over the page. That's why we lost. That's what I have to challenge. And in summary, my submission is that the judge was just a short step away from a finding of condemnation at paragraph 135, to some extent paragraph 137, and of course on the basis of all the very damaging findings that he made against Mr. Prentice. One short step. But instead, the learned judge made what I would respectfully characterise as a leap. He made what one might call an exonerating leap in this part of the judgment, and also in an earlier part of the judgment, when he moved to to draw the conclusion, come to the conclusion that Mr. Jones had not possessed the relevant type of guilty blind eye knowledge. And the grounds on which the learned judge made that leap, if it is fair so to describe it, appear in paragraphs 139 and 140. And the primary ground, particularly in paragraph 139, the primary ground is that appearing in lines 4 to 7, the self-preservation ground that has been canvassed in argument already, that the court is very familiar with. The court has my submission. I won't labour it. The court may accept it, may reject it, but we do criticise that as a matter of evaluation and logic, to say that given everything that is known now about the way Mr. Prentice conducts himself and the risks that he's prepared to take in relation to acting dishonestly and lying before trial and lying at trial, it is simply unrealistic, wholly unrealistic, to analyse the position as the learned judge is analysing it there.
Just wondering why you say it's a leap, though. I mean, it seems to me it's a conclusion. At the end of the day, the judge has to reach a conclusion based upon a very detailed and nuanced consideration of quite a large number of matters. It's not as though the concept of instinct for self-preservation has just come out of a hat. I mean, it's been something which has been a theme of his analysis throughout. So why leap?
It's a leap, my lord, because it's a step, but it's a big step, which involves obviously concluding, despite everything that is now known about Mr. Prentice, concluding not on the basis of any evidence that he's given directly, because of course he wouldn't have accepted the underlying premise, concluding that he would have been sufficiently concerned for his own safety and skin, as it were, on learning that Mr. Jones was misusing client money in a significant way to get out of Jirehouse.
Yes.
And the court has my submission. It may find favour, it may not. But
yes.
my submission is that to analyse the case in that way, given all the evidence that the learned judge rightly accepted by Mr. Prentice's misconduct, was irrational. Therefore open to review in this court on Henderson and Foxworth principles capable of being reviewed and leading to an appropriate order in relation to the judgment. Conscious of the time, my lord, my ladies, the other passage which I say contains a similar leap is the passage at page 139 through to 140, and that's the passage which travels from 93 and 94, which concern a document that did certainly show that purportedly Reno had lent £400,000 plus no doubt interest to John Street Bridge Finance, and which show that Mr. Prentice had read that document at the relevant time, moves from that down to 95, and then starts the consideration of the lien, and then down to 99, where the learned judge said this: the purpose behind raising the bills was plainly to reduce or extinguish an amount that had to be repaid. Raising, of course, is ambiguous there. There's two senses. The bills were raised, or were going to be raised in one sense. They were also inflated.
It means raising in amount, doesn't it?
Yes, I think so. But but that does not mean it was to reduce an amount of client money, that monies that could not be repaid. That was a possibility, but not one that I am satisfied Mr. Prentice knew or suspected. And bearing in mind also, of course, all the evidence that was available about the firm and Mr. Jones living hand to mouth in late 17 and 2018, I do make the submission that that was a leap, and it was not a sustainable leap. Simply was not a conclusion to which the judge could rationally come. I leave that.
Well, it begs the question, doesn't it? Why was he doing it? What is the possible reason why you would ask your staff to inflate their working hours to produce a bogus claim for work done to offset client monies, other than, well, I suppose two reasons could possibly be put. One is to put money to which they're not entitled into their pockets. The other is because you know you haven't got the money to pay what is actually due to the client, and therefore you're trying everything you possibly can to reduce that sum.
That's right, my dear, and I respectfully submit that the second reason is manifestly far more plausible an explanation of what was going on than the first. The first would have simply involved completely disgraceful fraud with a view to gain. Well, that's not inconceivable. That would hardly not really stand to the credit or advantage of Mr. Prentice if that is what was going on. And of course, what one can also draw from this unhappy part of the story is that on any view, Mr. Prentice was knowingly complicit in this particular type of fraud perpetrated on a client, in circumstances in which he must have known well that exposure of this could happen on an SRA visit or in some other way. Exposure of this would be lead immediately to an appearance in front of the disciplinary tribunal and then being struck off. But he was prepared to do that, and the court can take that into account. I'm now trespassing on in terms of time. May I make, I think, one further very short point, which is relevant to the scope and content of the issues that the parties, I think both parties, are asking the court to determine. Certainly, on our side, we are asking the court to determine this point. This is what one might call the temporary exigencies point. The court may find against us on the basis canvassed in discussions, which essentially is that the judge made the findings he made, having seen the witness, and this is not a matter which can be critically reviewed in this court. That is clearly one possibility. But the judge's observation, the judge's fallback position as to the misuse of client monies for temporary exigencies is one that I very respectfully submit this court should review in any event, and should not accept as the correct analysis of the way this clause works. A fraudster such as Mr. Jones, unlike all of us through life, of course, but in particular a fraudster such as Mr. Jones, is going to be dealing with temporary exigency after temporary exigency until the final exigency arises with which he cannot deal and which causes the roof to fall in. One knows that from commercial life and from the history of one's experience of frauds of this nature. The bright line, very important architecture of rules that are designed to ensure that solicitors look after client money properly, should, I respectfully submit, cause this court to analyse this case on the basis that it's simply it's wrong to say that there is a real and substantial difference between misuse of client money just to tide the firm over, deal with some problem from time to time in the hope that you might be able to rob Peter and then put Paul's money back in client account until the whole thing eventually unwinds, on the one hand, and major fraud of the Taymouth Castle nature on the other hand. That would be a wrong approach to all of the issues that arise here, and I respectfully invite the court so to find, even if I have failed to persuade the court, that our appeal on condemnation is well founded.
Well, there is something distinctly unattractive about the submission that, let's suppose in a hypothetical case, it is known. It was actually known to solicitor number 2, partner number 2, that partner number 1 was in the habit of helping himself to client funds as a day-to-day way of meeting the firm bills and then paying them back. Yes. And then he doesn't know, but he does know that there's this practice going on. And then eventually, solicitor number 1 snaffles £200,000 and pockets it and runs off with the money. He is condoning the theft of a steady stream of thefts from client funds. And speaking of myself, I don't think it matters whether they're big thefts, small thefts, or whether they're going to be paying the money back. He is condoning that type of dishonest conduct. And so I do have difficulties with the judge's fallback position.
Thank you, Lady. That very helpfully encapsulates my submission. And then, my learned friend will be upset if I don't mention his argument from Karim, which would lead to a construction of the axis clause as not providing for condonation by means of a condonation of a pattern of behaviour. His argument is that the axis clause has to be construed so that the condonation has to be, as it were, targeted on the specific fraudulent act and involve knowledge of the specific fraudulent act. I shall deal with this in a sentence. This is a compliment. It's a clever textual argument. It does not reflect common sense. It does not reflect the wording of the axis clause, and goes nowhere. The axis clause adjusts the wording from using the term dishonesty with a Y on the end to the term dishonest or fraudulent act or omission. I respectfully say, so what? Liability always arises out of fraudulent or dishonest act or omission. It doesn't arise nebulously out of the concept of dishonesty, and the axis clause covers the position entirely sufficiently and has, in substance, the same effect as the provision we find in the minimum terms. I'm most grateful to the court for allowing me to travel beyond 1 o'clock. Unless I can help further, there's my speech.
Thank you very much. Well, it won't surprise you to know that we're going to reserve our judgments. We will provide a draft in the usual way to the parties on the circulation list, and you'll by now be very aware of the strict restrictions upon its dissemination and the serious consequences for breach of that. We'd invite the parties to let us have corrections in the form of in relation to typos or other similar errors, not an attempt to re-argue the case. And we'd invite you also to attempt to agree an order reflecting the effect of our judgment. If you can't agree any aspect, then we'd ask you to make submissions in writing, and we will determine those consequential matters in writing. And then the judgment will be handed down in the usual way now, electronically without further attendance. I'd like to thank both counsel and all those sitting behind them for what has been a very well presented appeal, and that concludes the hearing.
Thank you.
All rise at table.